Hello, my name is Peter Rehon. I'm an attorney with the law firm of Rehon and Roberts in San Jose, California. I'm here today to talk about the newly effective rules of professional conduct in 10 minutes or less. So I'll have plenty of time for questions if you have any, but you won't because you're not here. The rules of professional conduct were adopted many years in the making, and they were modeled after the ABA model rules, but they are not the model rules of the ABA. California did its own thing, as it usually does. And today I'm going to discuss some of the highlights of those rules. Now, I only have 10 minutes, but keep in mind there are two reasons why you need to understand the rules of professional conduct. First, it keeps you out of trouble. Keeps you out of trouble with the state bar, with your clients, with the courts. But just as importantly, as a lawyer, we all have to be concerned about our reputation. And the best thing you can do as a lawyer is to cultivate a reputation as not only a lawyer who knows about the substance of the law, but also is scrupulous about following the rules of ethics and taking care to follow them. In addition to discussing the rules of professional conduct that were recently enacted, as a bonus, I am going to be discussing the newly enacted or newly amended Evidence Code sections 1122 and 1129. The importance of those sections can't be underestimated if you are a lawyer who ever takes a client to mediation, because effective January 1, 2019, every lawyer whose client goes to mediation has to provide written disclosure of the rules of confidentiality of mediation and actually has to get a signed disclosure from the client. So, and a lot of lawyers don't know about this, but it's a really important new revision that we can thank the legislature for. Let me go through briefly some of the rules of ethics that we're going to be talking about that are most important to you, practically speaking. As you probably know, all lawyers are required to put client funds in client trust accounts maintained by the lawyer, separate and apart from the lawyer's operating accounts. Those are sometimes called trust accounts or IOLTA accounts. Now, in a normal situation, it's not a good idea to write a check on your account where you have insufficient funds. But if you have a trust account and you write a check that bounces, the financial institution that maintains that account is required to report that to the state bar. And they immediately open a disciplinary matter. And in most cases, a lawyer who bounces a check, it does so accidentally. Like, for instance, a check is deposited and you don't wait enough time to allow the check to clear. But so the best rule to follow is to allow the check to have at least, to sit in your account for at least 10 days so it has a chance to clear. Now, and the other thing to keep in mind, particularly under the new rules of professional conduct, is that you can no longer blame your accountant, your administrative assistant, or another lawyer for some kind of mistake like that. Under the new rules of conduct, rules 5.1 and 5.3, lawyers have an affirmative duty to supervise both staff and other lawyers. So you have to make sure, you have to remember that you're going to be responsible for the mistakes of everybody. And that goes to a lot of other areas that we can discuss. The new rules of professional conduct also provides specific new requirements for flat fee arrangements. So for instance, if you agree to provide legal services for a flat fee, take a look at new rule 1.15, and it has all of the requirements for making sure the client, you disclose everything you need to do to the client and the client signs off on a flat fee arrangement. Let's talk about marketing. Under the new rules of professional conduct, they're not unlike the old rules that California had. The new rules are at 7.1 7.2 and 7.3. And what that means, what they provide for, among other things, is they, like the old rules, they prohibit deceptive or false advertising. But in this world where lawyers are blogging, are using Twitter, or using Facebook, there is a risk that some of those communications are going to end up with potential clients outside the state of California. And there have been other jurisdictions within the last few years that have imposed sanctions and opened disciplinary matters against California lawyers who were deemed to be practicing law in another jurisdiction just by virtue of their blogs, Twittering, and the like. So you have to be very sensitive and very careful about the kinds of communications you put out on the internet. And a lot of people don't know that, but that's an important thing to keep in mind. Let me talk for a second about the new mediation rules. Again, every lawyer who has a client who goes to mediation has to prepare a specific written disclosure that tells the client exactly what the rules of confidentiality are for mediation. All communications during, after, or about the mediation are strictly confidential and cannot be admissible in any legal proceeding. What the lawyer has to do before the client agrees to go to mediation is to provide that disclosure in writing to the client and obtain that client's signature on that disclosure. Now, the evidence code as amended has safe harbor language, and it provides the kind of language that the lawyer has to include in the disclosure. But again, if you have a client, whether you're a litigation attorney or transactional practice, and you're going to mediation, you have to do this disclosure and get the client's signature on the disclosure. I want to offer in closing a couple of tips that I would recommend. The State Bar produces a great book. It's a blue book which has all of the rules and comments in one place. And I would they're free. You can get it from the State Bar, and I would definitely recommend it. I've had the old gray book by my phone for years, and you cannot believe how handy that it has come in over the years. Secondly, to the extent you can cultivate a relationship with a lawyer you like and trust as a sounding board, I would, as long as you don't disclose confidential information to the lawyer, whether it's if he's outside your law firm, it's good to have somebody to bounce off ideas off of the lawyer whenever you get into there's a question or a pickle or something like that. And finally, every jurisdiction has rules of civility or rules of professionalism. Sometimes local bar associations do, sometimes various courts do that. I would highly recommend that you get a copy of those, read them, understand them, and follow them. As an old trial lawyer and a lawyer who spent a lot of time in front of judges, judges will always complain when a lawyer is not acting civil or professional, and will always compliment you when you do. So you always want to be the lawyer who's complimented by being professional and civil and decent. And it's also a good way to get business from your former opposing counsel. I've gotten a lot of business over the years from my former opposing counsel just because I was able to maintain, at least with some of them, a good relationship. And with that, the only other recommendation I would make is have fun. We are all lucky to be lawyers, and although some days it may not feel that way, I think you can make a great living and have a good time doing it. Thank you.